Hello and welcome. I am Deji Badimasi. The raging dispute between the federal government of Nigeria and the Academic Staff Union of Universities that has kept many universities short for more than 7 months now has become a legal tussle. The Minister of Labour and Employment, Dr. Chris Ngige, says the federal government resolved to take the union to court because talks between both parties have collapsed. He explained that the government wants the National Industrial Court to order Asuu members to resume work while the issues in dispute are being addressed by the court. The federal government in the suit also wants the court to interpret in its entirety the provisions of the law, especially as it applies to the cessation of the strike once a trade dispute is apprehended by the Minister of Labour and Employment and conciliation is ongoing. Meanwhile, Nigerian students have also decided to take to the streets in different parts of the country, saying the federal government led by the President Muhammadu Buhari's administration has failed on its promise to revamp education. Hundreds of the students occupied the Lagos-Ibadan Expressway in a protest that later resulted in a heavy gridlock. But the government has lashed back at the students, saying it is not in their place to obstruct vehicular movement on the expressway, adding that the actions of the students is a violation of the law. In the wake of all this, there's been continuous calls for the government to look for ways of resolving the dispute to allow Nigerian students resume academic activities. Joining me now to discuss this further is legal practitioner Edidiong Osungrua. Mr. Edidiong, thank you very much for joining us on the program. Let me start by asking you, do you think the court is the best place to resolve this ongoing strike action by Asuu?
All right, so thank you very, very much for inviting me to your program. And in direct response to your question, the answer is this. We live in not just a democratic world, we live in a world and a country that is governed by laws. So ours is a constitutional democracy. And as an integral part of dispute resolution mechanisms, the courts are set up to resolve disputes as between private citizens and as between government and private citizens. In light of that, the resort by the government to the court of law is only an exercise of the right available to the government under the ambit of the law. So I do not think that it is in itself implicitly wrong for the government to have initiated this action against Asuu.
Now, the reason I asked you that question is because I just can't think of any trade dispute that has been resolved by the court, especially the industrial court. I mean, we've seen situations in this country where the industrial court, for instance, gave a ruling or gave an order and the labor union simply ignored it. I'm just wondering if this would be any different at all.
Well, you see, ours is an adversarial legal system. Being adversarial, the import is that the resolution of a dispute one way or the other may not necessarily be to the best interest of all the parties. So if you are reasoning from that perspective, then it stands to reason that an amicable settlement is the best option. But then that raises a very, very genuine issue, and it is this. For a period of about 7 months, the principal parties in this impasse have been at the table of dialogue. And the essence of that dialogue was to have an amicable settlement of the issue. But has it worked? It hasn't worked.
That's true.
So in the circumstance, for the avoidance of breakdown of law and order and total collapse of the academic system, I think the resort to court is a proper thing to do. Now, whether or not...
Yeah, go on. You're saying whether or not. Go on, I can hear you.
Yeah, whether or not the outcome will be favorable to the government, that's an entirely different consideration.
Now, let me ask you.
I believe the government has acted appropriately by initiating the action in court to seek a judicial determination of the issue, one way or the other.
What do you make of the argument of the government that once a dispute, according to the Minister of Labor now, that once a dispute has been apprehended, so to speak, that is, once negotiation has begun over a labor dispute, then the labor unions should resume work and not go on strike? Because, you know, they've been talking all this while and they've been on strike. What do you make of that argument? Because the argument of the minister is that that is what the labor laws of this country says or say.
Well, you see, Section 18 of the Trade Disputes Act, its provisions are very, very clear and unambiguous. But before I go into that, let me say that since the action is sub judice, I am precluded from commenting on the merits or demerits of the case. Now, nevertheless, I would say that since the provisions of those acts, the provisions of Section 18 of that act are clear, it is to this effect that once a conciliator has been appointed over a trade dispute, now neither parties is to resort to any form of self-help. In the case of the employer, self-help by way of locking out the employee. In the case of the employee, self-help by way of a strike action. Now, those are the express provisions of Section 18 of the Trade Dispute Act. But it has been submitted for judicial determination, and we await what the court has to say on it as it relates to the unique and peculiar facts and circumstances of the instant case.
Why is that? I mean, it would appear the law is quite explicit, the way you have explained it, the provision of the law, especially as it relates to labor dispute. But why is it that this law is usually observed in breach, that, you know, the law is never followed? Because usually in this country, what we've always seen is that anytime negotiations are on, a conciliator has been appointed, it still doesn't stop the strike action from going on.
Well, this case presents us with a very genuine opportunity for specific pronouncements by the court on this recurrent decimal you've referred to. So it's a case we should look forward to with great expectations.
Okay, just before I let you go, let me get your own take now on the students who, I mean, you look at their action. The students who blocked the expressway in protest now against the continuation of the closure of schools, public universities now in the country. What do you make of the action of the students there?
Well, without gainsaying, the rights of every citizen are guaranteed in the Constitution. And as an integral part of that right, citizens have the right to protest against perceived injustice. Well, I use the word perceived advisedly. They have the right to protest. Yeah, but it is also very, very material to point out that in popular parlance it's said that where the right of one person stops, that of another begins. Again. Now, applying that to the instant case, we must appreciate that the provisions conferring rights on citizens are not absolute. And so the exercise of rights by citizen A ought not to infringe upon the rights guaranteed to citizen B. How do we apply that to the instant case? If the protests infringes on the right of commuters and other road users, it presupposes that in itself it defeats the very essence of the right conferred on the citizens to protest, because in so protesting you have violated the right of others. So in synopsis, I recognize the right of the students to protest, but at the same time I recognize the right of other citizens not to be put into jeopardy or undue hardship on account of the exercise of right of protest by students. Thank you.
Edidiang Usungura, thank you very much for your time, and thank you for talking to us.
You're welcome. Thank you.
Thank you so very much. All right, we'll take a short break now and we'll be right back. Stay with us.